Good afternoon and welcome to the SRA's webinar on small firms. I'm Jatinder Loyal. I'm a policy associate within the policy team of the SRA and have been with the SRA for over 12 years working with small firms, but also have experience of working in a small firm. So hopefully you'll enjoy what we have to share with you today.
Good afternoon to you all. My name is Dean Spencer. I'm a regulatory supervisor in the Supervision Directorate of the SRA. I've had some 38 years in practice, mainly as a civil litigator, and a substantial part of that service has been with small firms, mainly 2-3 partner firms. So I like to think I've got a real appreciation of what it's like to work in a small firm, the pressures, the competing obligations and duties. And the type of small firm that I supervise ranges from the more traditional high street practice to some of my firms that operate from their home address in perhaps a converted garage or whatever. So a broad cross-section of small firms. And as Jacinta says, I hope today that you're going to get some valuable insight into what we want to do to engage more with small firms.
One of our programs, or should we say one aim of our program of regulatory reform is to make sure that we regulate small firms proportionately. And we do all that we can to help them comply with our rules that's proportionate and appropriate for their size. What we don't actually consider, though, is that this is about compromising the regulatory framework, but about identifying steps that we can take to make it easier for small firms to comply. Some of the initiatives we've already consulted on in 2004, that's around the changes to the professional indemnity insurance arrangements, submissions of accountants' reports, which we consider will help small firms in the medium to long term. It's acknowledged that the SRA has done much over the past 4 years to improve our working relationship with some of the larger commercial firms. But it could be said that the same progress hasn't been made with some of the smaller firms and the sole practitioners that we engage with. So it's important that we engage with sole practitioners and small firms and hear their views as to how we can help them as we progress as an organisation. We've taken on board comments that have been fed through different forums, and in order to understand the pressures, the challenges that are faced by small firms and sole practitioners.
Yeah, I mean, having worked in a number of small firms, it's clear that it's tough. In terms of day-to-day practice, Friday completion day traditionally, has the report on title gone off? Has the client put me in funds for the balance of purchase monies? If you're a civil litigator, am I having to comply with a strict deadline in terms of an unless order? And of course, it's about resource and it's about competing interests and obligations. It's not always possible just to pass the file to someone and say, can you deal with this? Often it's entirely down to you. So from an SRA perspective, and certainly from my perspective as a supervisor of small firms, I need to understand the issues and the pressures that you as practitioners are facing.
And as Dean said, in order to understand the pressures, the issues or the challenges that practitioners face, we've engaged with a number of groups prior to the launch of our discussion paper, one of them being LawCare. LawCare is an independent organisation that helps practitioners at stages of their working life and have been instrumental in providing us with some really good feedback on the issues that face practitioners, whether it be in setting up their practice, continuing their practice, or even winding down their practice when it comes to that point in their career. The feedback that we have from LawCare has actually helped inform what we've now published on the SRA website through the regulatory starter pack that's around key issues that practitioners might need to take into account. And the same goes for the sole practitioners group. We've engaged with the sole practitioners group for a number of years now, and they've informed a lot of our policy direction, but also provided a good forum for us to engage with. And again, they've used this opportunity to engage with us to identify the key issues, the challenges that face sole practitioners, but also the sort of support that sole practitioners need from the SRA in order to ensure that they can meet the needs of their clients, but also to ensure that they're remaining compliant at all times. You may have also noticed that the Law Society established their sort of small firms division. This has now moved into a formal committee that will begin their work this year. Our engagement with the Law Society Small Firm Division, again, is to understand the key issues that they've been working on, the feedback that they've had from practitioners about what challenges a practitioner on a day-to-day basis and how regulation should actually be there to support practitioners in ensuring that they, again, meet the needs of their clients and can continue to survive in the changing legal landscape. So this webinar is an opportunity to find out about some of the proposals that we've been working on. It's also an opportunity to take part in the debate. You'll see from the information that we have published that there is a discussion paper out at the moment which closes for responses tomorrow. So we ask you all to take part in the debate, provide your comments, but also provide feedback on other areas that we can provide, whether it's information, whether it's guidance, or whether it's other webinars that we can put together that help you carry on doing your job.
What I'd also like to do later on is just to highlight some of the top regulatory issues that appear to be affecting some small firms. And I think that to alert you to some of these emerging risks will be of great benefit.
And just going from what Dean said as well, what will be interesting is the feedback that we receive from you. So the key challenges are what we've gleaned from those that we've engaged with, but this is an opportunity for you also to set out key issues or key challenges that you'd like further support and help on. Moving forward, you'll notice in the discussion paper that we've proposed a definition of a small firm. One of the key challenges that we've had in this work is deciding our approach. In deciding our approach is how we define a small firm. Given that much of the regulated community falls into the accepted definitions of a small firm or small business, so that's the definitions that people like Biz are working on in respect of small and micro enterprises. The definitions of extreme importance, especially if we're looking to change regulatory arrangements, and we'll go on some of the initiatives later on. But in discussions with practitioner groups and also the Law Society, we've looked at the potential definition, and we've come up with the definition that a small firm is either a sole practitioner or a firm with no more than 4 partners, members or directors, and has an annual turnover no more than 200,000 and has no more than 10 PC holders. So as part of the discussion paper, one of the questions that we have asked is, do you agree with our definition? And we look for your feedback.
I think that you should now have a voting button. So what I would suggest is that if it should be popping up on your screen any moment. Whilst you're casting your vote, certainly some of the feedback that I've had from some colleagues is that their suggestion is that perhaps £200,000 is arguably on the high side, and one suggestion was that rather than 10 PC holders, it should be no more than 10 fee earners. But of course, it's also interesting to note the 2 strategically placed words of "and" in paragraph A and B. So there's a whole myriad of different issues to consider there, but hopefully now you've all had an opportunity of voting, and we'll be able to have a look at the results.
The results that have come in. Okay, that's fairly interesting. The response that we've had back from those that have been able to work through the poll, 30% or just over 30% agree with our definition. 43% don't agree with the definition, and 26% are not sure. So focusing on those that don't agree with our definition, again, it's an opportunity for you to respond to the discussion paper and setting out why you don't agree with the definition that we've put forward. Again, this is not yet been agreed as the definition for a small firm. So it's important that we get it right by engaging with you and listening to alternatives that are being, should we say, mooted or discussed elsewhere. So we look forward to hearing from you. Moving forward, as part of the early engagement, we've set out some of our initiatives, one of them being is the small firm section of the SRA website. This was something that we used as a way of engaging with small firms and sole practitioners, but it was also based on feedback that we've received from the early engagement that we've had, that the website can sometimes, or should we say web material, can sometimes be difficult to navigate round. So what we thought was that to make it easier for small firms and sole practitioners was to have a one-stop shop, if you want to call it, for practitioners just to go on to and have a look at information that was either relevant to their practice, updates on recent guidance that had been issued, whether there was key events that sole practitioners, small firms were interested in, and just a way of communicating with the SRA. So the small firm section includes an opportunity for practitioners to sign up to the new small firms newsletter, and also to take part in engaging with us through joining the virtual reference group. The website also includes a regulatory starter pack that's been put together, and the starter pack itself was again based on feedback that we had from practitioners and also the practitioner groups. So it highlights some key areas that we expect firms to be thinking about. So it's resource planning, succession planning, how to manage client money, issues around data protection. It also includes links to recent guidance notes, warning notes that we've issued, and also references to external help that might be available. So it includes links to people like Law Care and the Sole Practitioners Group.
Certainly, so far as the virtual reference group is concerned, I know that I, as a supervisor, and my colleagues, we'll be joining that reference group to find out what the current topics of interest are, so we understand what's proceeding.
And just in relation to the dedicated ethics advice help as well, that's something that's been used in a positive way since its launch. So over the last couple of months, we've looked at the figures that have come through, and it's been positively received. So it is a resource that's being used, and hopefully will be able to be used going forward. What we'll use from that is we'll speak to our ethics advisor colleagues and listen to the key issues that are coming through, whether there's common themes that are coming through, and again, that will help inform whether we issue further guidance or even webinars that we work on later on in the year. So again, this is an opportunity. What we'd like to hear from you is, do you think the small firm section of the SRA's website is proving to be helpful? Again, as part of the discussion paper, or responses to the discussion paper, we would like to hear people's feedback on what's been presented so far, but also how the web section could be improved by way of additional information or links to other information that might be useful to other practitioners that they may not be aware of.
So hopefully, in a second, the voting box again will come up, and if you would care, please, to cast your vote as to whether you feel that the small firm section of the website is helpful. We'd be interested to know. We're always looking to improve and to listen to what you tell us in order that we can change things for the better, to give you more information, more resources, and that this level of engagement is so important in bringing forward the interests of small firms. So hopefully we should now have the results of the poll. Jatinder, we should be getting some results through. And like the Dean said, I think the
the web at the moment, or should we say the web section, or even should we say the website, is the main port of call for a lot of practitioners. With the moving technological landscape, it's important that we keep up and try and deliver as much information as we can through the right means. So rather than having hard copy material posted through your letterbox, it's important that we keep a section of the website up to date. And yes, Dean, we've had the response through, and it's a pleasing response. So 83% of those that are engaged with us at the moment said that the section of the website is proving to be helpful. So that's a really, really positive.
Yeah, and we would invite you, for those that feel that it can be improved, then please tell us how it can be improved, what you'd like to see in it, whether it should be expanded. This is the opportunity for you and for us to engage, to improve information that you need as practitioners.
And also an opportunity for you to tell us of what's actually working well. So does the regulatory starter pack provide you with the right information that you need as you're starting up your business? Do the links to recent guidance, are they helpful in the sense that you don't have to navigate the SRA's website? And engagement, the events that we've got going on, it's an opportunity to see what's happening. So we'll move on now to the initiatives going forward. Again, this is based just on the engagement that we've had so far. So again, I'm plugging the discussion paper and the need for practitioners, colleagues, peers to respond. But what we're looking for is, as we've created the regulatory starter pack, what we're looking to do going forward in the next couple of months is to create a guidance pack to help firms that need to close. Again, this was based on feedback that we've had from the practitioner groups and including Law Care here, where they said that closing down a practice was sometimes the hardest thing that a practitioner had to do, whether it was a sole practitioner or a small firm that comprised of 2 or 3 partners. It's important that from a regulatory perspective that a firm closes in an orderly way. What we don't want to do is have to intervene unnecessarily. Clients' interests need to be maintained, and it's important that there's consistency for clients going forward as well. So if a firm closes down and there's ongoing retainers that still need to be entertained, it's important that clients can see continuity. But in respect of a practitioner, they should have pride in the business that they've developed over the years, and if they do need to close for whatever reason, that it closes on a positive note. And Dean's had some experience of working with firms that have had to close, and we'll touch on some of those later on. And again, what we're looking to do, again, based on the feedback that we get from you, but also the feedback that we have from ethics advisors in respect of key themes that are coming through, is develop a series of webinars for small firms and sole practitioners. So that may be around things like confidentiality and data security, might be on closing your practice, might be on setting up your practice, might be about publicity and marketing, changes in the legal landscape, how firms are being affected by, for instance, the referral fee ban that came in a couple of years ago now, changes to criminal legal aid, and how the SRA can facilitate work going forward.
I mean, certainly on some of the cases that I receive on a weekly basis, that there are some reoccurring themes, and I think that some webinars which incorporate some of these key themes, I think would be very helpful, particularly in relation to money laundering and cybercrime, which we'll talk about in a little bit more detail. I've got some practical examples of where those have occurred. And then some practical ones, for example, residual balances on client account, and some issues arising from the SRA accounts rules. Other reoccurring themes such as breach allegations that there's been a breach of undertaking. But we can tailor these webinars. But again, you need to tell us what is going to be useful to you. We can tell you what the reoccurring themes are likely to be. But I think that between us we can come up with a series of webinars that you're going to find very useful.
And those will be housed on the SRA website, so the section of the website for small firms. We're hoping to get a library of webinars put together. And as Dean said, it's important that we receive your feedback, because I'm sure you wouldn't want Dean and I to be putting webinars together that have no relevance to anybody. So again, your feedback's important to us. So going forward, we hope that the regulatory starter pack, for those that have had an opportunity to review the information that's contained within that, and again that was based on feedback that we had internally and externally, it will be useful to know what people's perception and understanding of how useful that is through the poll that should now be appearing on your screen. So we're asking, has the small firms regulatory starter pack help provide assistance and support in considering key risks, and also how they could be managed? So the starter pack has been put together with the help of the SRA's risk team and reference to some of the material that they've published over the last year or so now, which is the risk outlook and the updates and the risk guides that have formed part of that as well.
So we have now another question. Has the small firms regulatory starter pack helped provide assistance and support in considering key risks and how they could be managed? So the box will be coming up in a second. Please cast your vote, and we will see what your view is regarding the starter pack. Obviously, probably not going to apply to a significant number of you, but nevertheless, we would be interested in some feedback on it.
Even though it's a starter pack, I think it should be used as a tool. There might be some issues or some comments that have been flagged in the starter pack that may not have been, should we say, considered previously in practice, or it might be that that the key risks have not always raised the profile that they need to be within a small firm or sole practice. So it's important that we get feedback, and like we said, that this is a living document, so hopefully the feedback that we get from you will inform other issues that can be included in the starter pack, and whether there's further guidance or support that we need to be giving. Should we see if we've got any results indeed?
Yeah, let's see whether we've got them. Right, the results are just coming through now. Jatinder, what are they?
Okay, results coming through. Those that have had an opportunity to consider the starter pack, again, 15% say that yes, it has helped. We've had a large response which says that they're not sure. So again, it will be good to hear from you in response to the discussion paper which closes tomorrow as to why you're not sure whether or not the pack helps. Again, it might be that, as Dean said, because you're not actually starting out, you might not have considered it. But hopefully it will provide an opportunity for you to look at the key risks that have been identified. And these risks are not just applicable at the outset of setting up in practice. They're continuing in the lifetime of the firm's existence. So maybe we need to call it something else. It shouldn't be a starter pack as such, but it's just a regulatory pack that's been put together.
It's a good point, because within the starter pack, insurance issues, PII insurance issues are raised, and in fact, some of the issues that I have or have had with some of the small firms that I've been dealing with relate to run-off cover. The whole myriad of different issues concerning run-off cover and all that entails. So there are common links between obtaining insurance and then looking at run-off cover.
Thank you. Thank you for those that have responded. But like I said, again, we would welcome responses through the discussion paper and also the virtual reference group. So do sign up to the virtual reference group because your comments will help. Moving on to the next slide now, we have initiatives going forward. Again, what we're looking at as part of the discussion paper, and this is what we've flagged, is that a review of the COLP and COFA, so that's the Compliance Office for Legal Practice, and Compliance Office for Finance and Administration, the authorisation requirements around that. Feedback that we've received is that in cases where there needs to be a change of a COLP or COFA, sometimes it's unnecessary and unduly burdensome on small firms to go through the process when they've already been deemed approved to be managers or owners of their business. So that's something that we'll be looking at. And again, it's important that we get feedback on any other initiatives that we could consider going forward as well. We're looking at the small firms supervision team. And Dean, do you want to?
Yes. Now, so far as the supervision team are concerned, what I would say is use the supervisors as a good point of first reference. Often, some of the firms, the small firms that I supervise, they'll pick the phone up and say, Dean, I've got this issue with regard to a PC, for example. That's probably an authorisation issue. I can then walk across the office, speak to authorisation, put them in touch. I have an understanding of the firms that I supervise. I know how they tick. I know many of the individuals there and what their difficulties are. And I can, and my colleagues can act as a point of first reference for a very significant array of different specialities and talents within the SRA itself. The other point I would make is that from a supervisor's point of view, I'm always looking to resolve issues as early as possible. I think that early resolution is generally good for the consumer. I think it's good for the SRA, and I think it's good for you as the practitioner. A typical example of this is where a few weeks ago I had an event where it was reported that the firm of solicitors, a small firm, had failed to comply with the publicity regulations in the SRA Code of Conduct, which was outcome 8.5, in relation to authorised and regulated by the Solicitors Regulation Authority. And it simply meant picking the phone up and having a discussion about the deficiency in the letterhead in this particular instance, and in a very efficient, proportionate, appropriate way, the matter can be resolved by saying, well, this is what outcome 8.5 says. If you can arrange, please, when the stationery is reprinted, to have the appropriate wording on it. And that's a very quick and efficient and proportionate way of dealing with a low-level risk issue. Clearly, not all my events are like that, and some are difficult and complicated investigations. But the thrust of what we want to try and do in supervision is to try and resolve these issues as soon as possible, but ensuring that there is a thorough and complete investigation of the facts and circumstances.
I think what we can glean from Dean's comments around supervision is that engagement is key, and that's early engagement. And we need to engage with practitioners at all fronts, whether it's in relation to regulatory policy, operational policy, investigation of reports that are coming into us, how we help you through the renewal of your practicing certificate on a yearly basis, any other issues that you want to engage with us on. So whether it's through the work that our equality and diversity team are doing, it's all about engagement, and that's something that we would like to, should we say, push through this webinar, which is that engagement is key, early engagement is key. If you need help and support, you've got the Professional Ethics Helpline, the SRA Contact Centre, but as Dean said as well, your supervisor. So if you do know who your firm supervisor is, do pick up the phone, do engage with us at every opportunity.
The important point about that Jatinder's just made is that frequently, if a firm picks up the phone and they ring me and they say, Dean, this is the situation, this has occurred, I just need some guidance, would you like me to send you an email? Often, it's so much easier to deal with it when you know about it at an early stage, because as we'll see from some examples of matters that I've dealt with recently, if matters are dealt with promptly, often it prevents things from getting worse. So don't be worried or frightened about picking up the phone and having a discussion with your supervisor.
So we've talked a lot about our initiatives and what we've planned or what we have already launched in respect to the web information, the virtual reference group. But we're sure that you can think of other initiatives, other proposals that we can be thinking of and developing with you. So please take part in the discussion, provide us with your suggestions. We will be taking questions at the end of this webinar, but do feel free to submit your questions throughout the course of the remaining time that we have. But also, please do feedback to the small firm discussion points. So if you do have an opportunity later on today, do log on to the SRA's website, and it's sra.org.uk/small firms, and that will give you a link to how to respond to the discussion paper, but also use that as an opportunity to provide any other comments that you want to give in respect of initiatives going forward.
We're going to have a look at some examples of key risks, and although it's true to say that these key risks can also apply to medium and large size firms, certainly in my experience, financial difficulty, financial instability, I'm seeing more events coming through in relation to that. And it's, again, true to say, I think, that some of the warning signs of financial instability, generally speaking, don't occur overnight. Again, if there are issues, there is an obligation under the handbook to promptly notify the SRA in the event of serious financial difficulty. But of course, in a small firm, it's often just down to you. There may be a cashier, there may not be. There may be an assistant solicitor, there may not be. There may be another partner. But it is often more difficult for a smaller firm to obtain funding or investment. There are perhaps no other backers, and therefore, by definition, there are fewer options. It may well be that the only real inroad into further funding is by a discussion with the bank manager or the bank relationship manager now down the road. The other difficulty that is frequently faced by small firms is that they don't necessarily have the ability to diversify in their caseload. Some of the firms that I supervise, probate and conveyancing, perhaps with a little bit of family law, but they would find it very difficult in a downturn to diversify. Large firms, they may have a specialist commercial litigation department, commercial property, residential property, admiralty, white-collar crime, you name it, they've got a department. And therefore, it is more difficult for smaller firms to diversify depending upon the financial strictures that there may be within the general economy.
And as Dean said as well, it's an important issue that firms need to be aware of, and it's not something that happens overnight. So it's making sure that you've got full control of your firm. Something that popped up last year and the year before, having been involved in the SRA's financial stability project and thematic review of firms that were failing, what we did produce was some information and resource for firms to look at. And that's included in the SRA's Code of Conduct under Chapter 7 of Management of Your Business. There's the resource tab which goes through a firm's responsibilities, managing your finances, and also what we did do at the time was highlight some poor and good behaviours. So it's important that people take note of the guidance that we've issued, and good behaviours, again, it's looking at making sure that if you're a small firm, that, amongst partners, that financial information is being reviewed at appropriate stages, it's being shared with the appropriate people within the office, provision is made to fund partners, tax from income received, premises costs are contained. It's those sort of behaviours that we're looking for. And again, we won't dwell on the poor behaviours, but it is important that we highlight certain issues and risks that are associated to managing your firm. Within the starter pack, again, we've taken the opportunity to highlight under the resources section and finances section of the starter pack as key issues that firms might want to take into account. Moving forward now, this takes us on to another key risk, and again, this is something that was brought to our attention through the financial stability work that we've done and engagement that we've had with firms, but also it was highlighted as a key risk that practitioners face through our interaction with groups like Sole Practitioners Group and also Law Care. It was upsetting to note that a lot of firms don't really think about succession planning or contingency planning as part of their business. And that's not a criticism of small firms or sole practitioners, because their prime objective is to serve the needs of their clients and make sure that they have a viable business. But in relation to succession planning, it's not just about closing your business when you reach retirement age, for instance, or think about going into another career field. This should be at the start of everybody's, should we say, business planning when thinking about the viability of their business going forward. None of us can foresee what will happen tomorrow, so it's important that we've got sufficient and proper arrangements in place to ensure continuity of client matters.
I don't think it should also be underestimated as to how long it can take for a firm to wind down in an orderly way. We'll see a real life example of this in a few moments, but it should not be underestimated. It is not simply an overnight or a weekly or a monthly exercise. It takes planning. There are also side issues in relation to that if you are, for example, a sole practitioner and you're seeking to put in place contingency provision in the event that you're incapacitated, for example, you would also need to bear in mind any issues that might arise in relation to confidentiality. So if you have a firm that you know very well down the road that would come in and assist in the event of your incapacity, you do have to also bear in mind the obligations that you have under the handbook in relation to confidentiality.
And it's important to note that there are groups out there, so for instance Law Care, they provide a lot of support, but it shouldn't be support that's used or, should we say, taken up when things start to go wrong. In our engagement that we've had with Law Care, they're very positive in engaging with firms at all stages of a firm's life cycle. So even at the point of startup or during the course of the firm's journey, what will happen is that they're happy to engage with you and signpost you to whether it's commercial organisations that might be able to provide support or other organisation groups that might be able to help you.
Ellie, we do see our next screen now. What we're going to do now is we're just going to have a look at a brief case study. This is a matter that I dealt with, and in fact I'm still dealing with at the moment. And it's an illustration of a number of different issues that affect small firms. I supervise a small 3-partner firm, a firm that actually, looking at their turnover, was doing pretty well. Unfortunately, there was a dispute between the 3 partners, which resulted in the coffer leaving and going to another firm, another partner leaving to go to another firm, leaving the culp in situ. So from a three-partner partnership law practice, we were left with a situation where we had only the culp in occupation of the office. And I received a telephone call from a firm of solicitors that deal with regulatory matters, and the call was to the effect that, well, I've looked at this matter, it looks hopeless, you are going to have to intervene. And we contacted the firm to obtain all the relevant information, and it would have been it wouldn't have been very easy, but it would have been certainly appropriate to have considered whether this was a suitable case for intervention, particularly having regard to the interests of clients of the firm. What we were left with was a situation where we had a culp who was practicing without the appropriate authorisation. So immediately what we had to do was contact authorisation department and regularise the position. The firm obviously need to contact the insurers, so the insurers are on board. And what we were seeking to do was to achieve a good outcome for the client, a good outcome for the firm, and a good outcome for the SRA. And what was key in this particular case was the communication between the SRA and the firm. We worked very, very closely together. Very intensive engagement took place with a view to winding down the practice rather than the case proceed by way of possible intervention. And one of the issues that arose that might have become a major issue was their document destruction policy, because they had retained something like 50 years of financial records. And when you're dealing with an orderly wind down, you're dealing with vast amounts of old files and other documentary material. It has to be put somewhere, and it has to be kept secure and confidential. So it was a document destruction policy that had never really been implemented and could have caused an impediment to the orderly wind down of the practice. But we worked very, very closely with the three partners with a view to the orderly wind down, the reduction of the client balance, which is now down to a very small amount. But I think it just illustrates the fact that what appeared on the face of it to be an intervention, actually, with close engagement and with a good outcome in mind, the matter can be dealt with in an appropriate and proportionate way.
Another key risk that we're seeing is that there's ineffective systems and controls, and some of the feedback that we had was that large firms will have compliance departments, they'll have dedicated teams working on compliance issues, so they'll be aware of all the publications that the SRA issues, that other organisations like the Law Society, Sole Practitioners Group, or just generally in the legal media, that there is information being released. So one of the issues was that sole practitioners or small firms don't have time to go through all of that information. The experience that Dean and I have had in working with, should we say, sole practitioners and small firms is that systems don't need to be all singing and dancing. What's required through the code and general regulations is that the systems need to be effective. How you do that is up to you. What works for you is only something that you can decide, but it's making sure that those systems can be reviewed at appropriate stages in order to ensure that they are effective. And if you need help, then that's where people like our advisors on the Professional Ethics Helpline can guide you through the requirements that a firm need to have in place in respect of managing your firm.
It's interesting this, because when Jatinder and I were talking about this, one of the things we said was you're frequently saying to clients about a will that a will is something which is written at a moment in time, but it may need to be changed depending upon the changing circumstances of the dynamic of the individual. Well, similarly, effective controls and systems in a small law firm may need to change as it grows. So always be aware of the need to review and change your systems and controls. We're now just going to come on to another case study. I supervise a two-partner firm, really nice firm. I know the senior partner there. I have very good regulatory history. This is a case where all the completions were lined up for Friday, and the cashier at the firm, been with the firm for years and years, received a telephone call, quite a routine telephone call from the bank, had a conversation, and very shortly thereafter they discovered that there was no money left in client account. They had been, on the face of it, the victims of a cyber attack, and there was no money available for completion day. The firm immediately contacted me. They contacted their insurers, and the insurers instructed solicitors to carry out a full and proper investigation. Now, I've placed there on the slide the obligations under Rule 7.1 and 7.2 of the SRA accounts rules, which is the overarching obligation to promptly repay into client account any shortage. Now, clearly, between the insurers being notified and an investigation taking place, it was necessary for the firm to contact the bank and to put into place emergency arrangements. If those arrangements had not been put in place, there would have been an obligation on the partners to put that money back promptly. So I think that one of the key areas, in my experience, of vulnerability is in relation to IT, and particularly this particular example. I can give you several examples of recent cases where this has occurred. So it's not meant to frighten anybody. It's just made to make people aware that there is a level of sophistication now that if a bank calls, it's probably a very good idea to carry out some checks, some due diligence to ensure that the person that you're talking to is who it is who you think it is. So again, this cyber attack is very much at the forefront at the moment of some of the events that we're receiving.
And this moves us nicely on to another key risk that we're seeing, which is bogus firms. There's been a massive increase in the number of, should we say, as Dean mentioned, cyber attacks. And this includes firms being exposed through identity theft of a firm, which it could be an existing firm or a firm that's recently closed, or even individuals. We've seen cases before where individuals that may have passed away have had their identity or their details used in order to facilitate money laundering and the receiving of monies in large transactions. So there's a risk to you as an individual, as a firm, as a practitioner, but there's also the risk to consumers losing out in respect of client money going missing and confidential information being lost as well. We've seen recent cases where confidential information is being disclosed to third parties that are not related to a transaction. The client doesn't know about it, and people like the Information Commissioner's Office are issuing guidance constantly to ensure that people safeguard against this risk. Again, it has a huge impact on a firm's reputation and has other negative impacts. Again, what we've done as part of the starter pack or the regulatory pack that was put together for small firms on the website is what can you do to minimise this? And we've said, as Dean mentioned as well, it's important to carry out regular internet checks of your firm's name or identity. Check your firm's details on the Law Society's Find a Solicitor website. Being alert to suspicious incidents, whether it's geographical location that you're working in or just the areas of work that you're involved in, and check the SRA's website as well for scam alerts. And if you are aware of anything that doesn't look right in respect of when you are engaging with another firm, report that through to our Red Alert hotline.
5 words, really. Don't take things for granted.
Exactly. And that moves us on to the end of our webinar. We do please get involved, respond to the discussion paper, provide us with your comments on the early initiatives and what we've published in the discussion paper. Feedback, use it as an opportunity to let us know what else we could do, where we could improve. Are there other areas that we can provide guidance on? And do take the opportunity to join the virtual reference group. It's free. It's something that we will use as we develop policy, whether it's regulatory policy, policy in education and training, developing our risk outlook, how supervision and authorisation engage with you as practitioners, and also sign up to the email alert. The first email alert went out last week and had links to information that we'd recently published. So do get involved. We'll now take questions.
The other thing I just emphasise to you is please don't hesitate to pick up the phone to speak to a supervisor if you need to. We are here to try and resolve problems, not to create them. So we're here to assist you and to help you.
Okay. Thank you for those that have submitted questions. We've got just under 7 or 8 minutes left. So we've had a few questions come through. We're happy to take more questions. If we can't get through everybody's questions today, do use, like I said, the opportunity for the discussion papers to provide comment or questions. So one of the questions that we've had is around the definition of a small firm. And as I mentioned earlier on at the beginning of our discussion today, that this is probably one of the biggest challenges that we've faced in this piece of work is to how do we define a small firm. Again, we've looked at definitions that people like BIS and other organisations have put through. There is the Enterprise Act going through at the moment, which includes a definition of a small and micro business. If we took those definitions, we would probably take in the majority of the regulatory community within that. So we've had to look at what works for us in respect to providing dedicated resource to this area of work. So the definition that we've got is out there. It's in the second or third slide that we presented today. But what we're looking for is to refine the parameters through the discussion and look for feedback that we get from you. So please take the opportunity to provide any feedback that you have there.
I've got another question here about what mistakes do small firms regularly make? Well, regularly make, I suppose that in general terms, looking at some technical issues of qualified accountants' reports, but really it links to the last point that I was referring to, and that is that I think that there are some firms that have become a little bit complacent in terms of cybercrime and also money laundering. I have seen events recently where small firms have been particularly targeted by the criminal fraternity because they are seen by some as being a soft touch. There are some other very large firms that have a host of security measures in place that reduce the risk of either being involved in money laundering or the associated cybercrime. So I think that the message is, as I said before, don't take anything for granted. Carry out comprehensive due diligence checks. Ensure that your controls and systems are appropriate and sufficient for your particular practice. We see certain trends of where, for example, a small firm is instructed by a new client in a remote location of which they have no prior knowledge. They don't know where the work came in from. It's of a type of work that is extremely unusual for them to deal with. I think that you need to start asking some more questions and being diligent in ensuring that these are bona fide transactions. So just beware.
Another question that we've had through is that would it be possible to repeat the webinar that was issued on closing down your practice? That's something that we will look at, and again use the opportunity to provide feedback on any other webinars or other areas that you would appreciate webinars on. So that's something that definitely Dean and I will take away, and whether it's Dean and I that present again or somebody else from the SRA, we will keep you informed.
I will tell you that to effect an orderly wind down it's actually more of an art than a science, because there are so many imponderables, and every practice is so different. I've mentioned about document destruction policies. Some firms, of course, don't have a document destruction policy. I think that doing an orderly wind down webinar would, I think we'd be able to give you some real added value on that.
Okay, and finally, one of our last questions, sorry to those that we haven't been able to respond to, but one of the questions is that who else will we be engaging with throughout the course of the year? Well, it's you as practitioners, but also other practitioner groups, as we mentioned, the SOC Practitioners Group, Association of Women Solicitors, and a range of other groups that have been put together to support and represent the practitioners that they engage with. We're coming to an end, and we'd just like to take the opportunity, both Dean and I, to say thank you for taking out the time to engage with us and listen to this webinar. You can download the slides from the resource tab on the webinar interface. You have until tomorrow to provide your responses to the discussion paper, but that's not the end of our engagement with you. Do continue to provide feedback through the SRA's website, which is sra.org.uk/small firms. And if there is other issues that you want information on, do get in touch. Do speak to professional ethics. If you're not sure who your firm supervisor is, it's probably because there are no issues for us to engage with you on. But if you do have issues that you need help and advice on, speak to professional ethics. If it means that supervision need to engage with you, then professional ethics will make that contact for you. So
I think the only other thing is that I think you're being asked to give your feedback on this webinar. Please do so. We want to constantly, as you want to move forward with your practice, we want to move forward with what we're trying to provide to you as sole practitioners and small firms. So please give us your feedback, and we would value that.
Hope you've enjoyed today's session. So we'll end by saying thank you from Jatinder.
And thanks very much indeed, and a very good afternoon to you all.
Thank you. Bye-bye.